Good morning, good afternoon, and good evening to you, wherever you are in the world. Welcome to the SIAC Academy Lecture. My name is Hannah, SIAC Strategy and Development Manager Legal, and I'm pleased to be your MC today. First, some housekeeping matters. Please ensure that you have your full name on your screen so that we can easily identify you for record-keeping purposes. You may send your questions to the panelists using the Q&A function during the post-lecture panel discussion. As we have limited time, the panelists will try their best to address as many questions as possible. I would now like to invite Ms. Michelle Chiang, Director of Academy and Projects at SIAC, to deliver the welcome address. Ms. Chiang, please.
Good evening, everyone. Thank you for joining us for the SIAC Academy Lecture 2023. This is the third year we are holding this lecture, and with your support, we hope to continue organizing a lecture like today's to round off each year. As the year draws to a close, I would like to share some highlights of the work of the Academy. This year, the world finally emerged from the pandemic. This presented an opportune time to hold our first in-person Academy course since the pandemic. The inaugural two-day written advocacy course titled A Typical Arbitration Proceeding, Written Advocacy, was launched in Singapore in February. Participants of this intensive two-day hybrid course were provided with a fact scenario of a hypothetical case and were guided through the stages of a typical arbitration proceeding as they crafted a case theory, drafted a notice of arbitration, responded to the notice, selected and interviewed their mock arbitrators, prepared for their first preliminary meeting, mock application for consolidation, request to produce documents, as well as drafted an outline of a mock written statement. We were delighted that 49 online and in-person participants from Australia, Cambodia, China, Germany, India, Indonesia, Japan, Malaysia, Philippines, Singapore, South Korea, Sri Lanka, Thailand, the UK, and Vietnam participated in this course. An in-person edition of this course was also held in China in May. In addition to a written advocacy course this year, SIAC also conducted an in-person oral advocacy course in India, the second edition of the two-day primer course of investment arbitration, the 2022 edition of the Review of Key Arbitration Developments and Decisions Singapore and UK seminar, as well as parts 3, 4, and 5 of the specialist arbitration series, focusing on insolvency, banking and finance arbitrations, maritime and shipping arbitrations, and IP technology and cryptocurrency arbitrations. This year, we had 693 participants from 30 jurisdictions attending the 8 academic training courses conducted in Singapore, India, China, and virtually. This is close to double the number of participants that we had for last year's courses. We are heartened by the strong interest and support from the international arbitration community, and we hope to continue to introduce interesting and practical arbitration courses that will be useful whether you're a practitioner, arbitrator, or user of international arbitration. We would also like to take this opportunity to record our sincere gratitude to all members of the SIAC Academy teaching faculty for taking the time to teach in our courses and for generously sharing your knowledge and experience. We would also like to thank all participants for attending and supporting our courses. Looking forward to next year, it looks set to be a busy year. In January, we will welcome the new year with the 2023 Review of Key Arbitration Developments and Decisions Singapore and UK seminar. This will be followed by the third edition of the Investment Arbitration Primer course in February. We will also be launching a Global Enforcement of Arbitral Awards Theory and Practice series, which will be held over the next few years. In 2024, the series will be focusing on the enforcement of arbitral awards in Singapore, China, India, UAE, USA, and Brazil. The efficacy of arbitration as an effective dispute resolution mechanism depends to a large extent on whether the integrity of the award will be protected by the national courts in enforcement and annulment proceedings and treated as final and binding save in limited circumstances. This global series follows from an earlier Enforcement of Arbitral Awards in Asia series that we had conducted in 2021. In this global series, we hope to provide an overview of the arbitral laws in different jurisdictions with focus on the theory and practice of the Enforcement of Arbitral Awards, the definition of arbitral awards, the grounds for non-enforcement of awards, annulment of awards, as well as the national court's attitude and approach in applying these grounds. The series will also touch on the practical strategic aspects that a foreign party seeking to enforce an award in that jurisdiction should take note of, as well as strategies for identification of assets of an award debtor within those jurisdictions. The full course listing for 2024 may be found on the SIAC website under the SIAC Academy page. We hope to see you at our SIAC Academy courses next year. Back to this evening's agenda. Today's SIAC Academy lecture is part of SIAC's efforts to provide a global platform for dialogue on topical issues of interest in international arbitration and to promote thought leadership. Our keynote speaker for today's lecture is Mr. John Fallis from the US. John is a full-time arbitrator and an adjunct professor of law at the New York University School of Law and an honorary professor at Durham Law School. He has been ranked in Who's Who Legal as a global elite thought leader. John will be speaking on rethinking the theoretical frame of arbitration. At the close of the year, it is an opportune time to pause and reconsider the theories that underlie the practice of arbitration and whether an arbitration agreement should just be treated like any other contract. We hope today's lecture will provide much food for thought. Without further ado, I will now pass the time over to John. John, please.
I'm not able to turn on my video. Great, thank you. It is a pleasure and an honor to be invited to deliver this lecture today. My topic is rethinking the theoretical basis of international arbitration. I'm going to discuss a dominant theory that underlies arbitration law, the theory that asserts that an arbitration agreement is just like any other contract and therefore should be treated just like any other contract. I'm going to argue that this dominant theory is fundamentally incomplete, that viewing an arbitration agreement as just like any other contract blinds us to important features of arbitration law that are essential to the efficacy of the arbitration process. I have divided my remarks into four main parts. In the first part, I examine this dominant theory and its philosophical underpinnings. In the second part, I argue that if the best test of any theory is whether it fits the facts, then the dominant theory is questionable because it cannot explain some key concepts in arbitration law, of which I consider two examples. In the third part, I focus on where I believe the dominant theory goes wrong at a theoretical level. I will try to show that contrary to the dominant theory, an arbitration agreement is not just like any other contract, and as a result, it requires for its efficacy certain doctrines that treat arbitration agreements more favorably than other contracts. In the fourth part, I will provide two nuances to my argument, and then I will conclude. Let me begin then with the first part of my remarks, a discussion of the dominant theory in arbitration law. Now, there are very few works of theory in the field of arbitration, and this is somewhat surprising given that arbitration rests on concepts like autonomy that have deep philosophical resonance and raises questions of legitimacy that parallel those that have long puzzled political philosophers. One reason for the paucity of theoretical work in the field, I believe, is that there is a dominant theory that is viewed to explain everything there is to explain about arbitration law, and that ties together the concepts of autonomy and legitimacy. And here it is in a nutshell. An arbitration agreement is just like any other contract. The terms of a contract express the autonomy of the parties who entered into it, and in the case of an arbitration agreement, it is their consent that is the basis of the legitimacy of the arbitration process. But not only does this dominant theory have explanatory force, tying together arbitration's central concepts of autonomy and legitimacy, it also has a venerable philosophical pedigree. The word autonomy is derived from the ancient Greek words autos, meaning self, and nomos, meaning law, which together mean a law I give myself. And in his book, Groundwork for the Metaphysics of Morals, Immanuel Kant relied on the notion of autonomy as the basis for deriving his famous categorical imperative, the moral law we give ourselves as rational, free beings. In the same way, a party expresses its autonomy when it agrees to arbitrate. Parties bind themselves to a form of dispute resolution, the terms of which they choose for themselves. After all, what is a contract, if not a law I give myself? Similarly, the notion that a contract provides the foundation for legitimacy finds expression in the works of political philosophers such as Hobbes, Locke, and Rousseau, who invoke the notion of a social contract to explain why it is legitimate for government to have a monopoly on the exercise of coercive power. And the same goes for an arbitration agreement. According to this theory, what is the legitimate basis of arbitral authority? The authority to issue an award binding on the parties that can be enforced in the courts, not a social contract, but a private contract between two or more parties to resolve a particular dispute by arbitration. Thus, the notion that the basis of arbitration lies in a contract has a roster of luminaries to back it up and explains and unites key concepts that are viewed as foundational to the field: autonomy and legitimacy. And this idea, the idea that an arbitration agreement is just like any other contract, finds prominent expression in the law. Now, in saying this, and as a general matter in much of what I have to say today, I will focus on US law, since that is the law of which I am least ignorant. This notion that an arbitration agreement is just like any other contract underlies the major statute that governs arbitration in the United States, the Federal Arbitration Act. That act was passed in 1925, and with the exception of the addition of provisions to incorporate the New York Convention and the Panama Convention, has remained virtually unchanged since. Prior to 1925, US law was hostile to arbitration, and arbitration agreements were revocable at will. What that meant is that if you agreed to an arbitration clause in a contract, you were entitled to revoke that agreement at the time a dispute arose. The rationale for why arbitration clauses were revocable at will rested on the fact that access to courts was viewed to be a fundamental right. And that right was considered to be so fundamental, even if you signed an agreement to arbitrate, you could change your mind when a dispute arose and revoke your agreement to arbitrate and choose instead to have your dispute resolved in the courts. This revocability doctrine, as it was called, was a special rule that applied to diminish the force of arbitration agreements. You weren't really bound by an agreement to arbitrate if you didn't want to at the time a dispute arose. The Federal Arbitration Act changed that in 1925, and being a federal statute, it applies throughout the United States. It overruled the revocability doctrine and said that an arbitration agreement was to be treated just like any other contract. And the rationale for this approach was laid out clearly in the legislative history of the Act, which states, and I quote, "Arbitration agreements are purely matters of contract, and the effect of this bill is simply to make the contracting party live up to his agreement. He can no longer refuse to perform his contract when it becomes disadvantageous to him." An arbitration agreement is placed upon the same footing as other contracts where it belongs. This very same principle, the same footing principle, or the equal footing principle, continues to find expression in US law today, almost 100 years later. Writing for a unanimous Supreme Court just last year, in the case of Morgan versus Sundance, Justice Elena Kagan voiced that same principle, stating that the underlying rationale of arbitration law is to, quote, "place arbitration agreements upon the same footing as other contracts, to make arbitration agreements as enforceable as other contracts, but not more so, to treat arbitration contracts like all others." This view of arbitration is so dominant that we barely notice it. It is the hidden foundation of the edifice of arbitration law. And in my view, it's the reason we have so little theoretical work in the field. We have a theory that explains it all, and we no longer have to debate it or discuss it or worry about it. And in this talk today, I do want to debate it. I'm not going to argue that this dominant view of arbitration agreements is entirely wrong, so much as that it is fundamentally incomplete. It overlooks a critical way in which an arbitration agreement is different from any other contract. This brings me to the second part of my remarks. Scientists tell us that the test of any theory is whether it fits the facts, whether it is consistent with the empirical data. I will argue that the dominant theory does not fit the facts, that there are critical ways in which the law does not treat an arbitration agreement just like any other contract. Rather, it often treats it more favorably and for good reason. Before addressing what is missing from the dominant theory, I want to consider two examples of how the law treats arbitration agreements more favorably than other contracts. The first example is a doctrine with which I suspect everyone tuning in will be familiar, and that is such a fixed and universal part of arbitration law we no longer notice just how strange it is. And that's the separability doctrine. As we all know, under the separability doctrine, challenges to the validity of the underlying agreement, for example, that it is invalid because it was induced fraudulently, or that it is invalid because it is illegal, do not necessarily impact the arbitration clause contained within it, because that clause is presumed to be a separate contract. But the separability doctrine is, of course, illogical. If a contract is invalid, it follows that this invalidity impacts the entire contract. Each of the terms contained within it, including the arbitration clause, is as a logical matter also invalid. The separability doctrine operates by singling out and giving more favorable treatment to an arbitration clause, saving it from invalidity in circumstances where the other terms of the contract would fail. In most of the world, the separability doctrine is provided for by statute. For example, in Article 16 of the UNCITRAL Model Law. In the US, it is the product of case law. And indeed, much of US arbitration law is judge-made because, as I said earlier, the Federal Arbitration Act was passed in 1925 and has barely been revised since. And we will get into the reasons for that in our discussion after my remarks. Separability doctrine was first adopted by the US Supreme Court over 50 years ago in a case called Prima Paint versus Flood and Gotland. And even though the separability doctrine is very familiar now, it was somewhat controversial then, being the subject of a strong dissent. Prima Paint is a tale of two companies that manufactured paint. Prima Paint entered into two contracts to purchase Flood and Gotland, and the contracts contained an arbitration clause. During the negotiations, Flood represented that its financial condition was healthy. A week after the contracts were signed, Flood declared bankruptcy. Prima Paint obviously wanted to get out of its agreement to buy Flood now that it was bankrupt. Despite the arbitration clause, Prima filed a lawsuit in federal court in New York to rescind the contracts and enjoin Flood from commencing arbitration. It argued that the contracts had been fraudulently induced, and therefore that both contracts and the arbitration agreements contained therein were invalid. Its theory was straightforward. If an entire contract is invalid because it was fraudulently induced, logically, so is the arbitration agreement within it, and so the validity of the contract had to be resolved in court. The question before the Supreme Court was whether a court should resolve the issue of the validity of the underlying contract, or whether that issue should be resolved in arbitration. A Supreme Court majority held that the case should go to arbitration, and it relied upon and adopted the separability doctrine, which had already been adopted by an appeals court. In doing so, the Supreme Court majority offered this rationale, quote, "The arbitration procedure, when selected by the parties to a contract, be speedy and not subject to delay and obstruction in the courts." I'd ask that you keep those words in mind, as I will come back to them. Justice Hugo Black issued a strong dissent joined by two justices, and he dissented precisely because instead of treating arbitration clauses just like any other contract, which was the entire point of the Federal Arbitration Act when it was passed in 1925, the majority was treating them more favorably. And he said, quote, "The avowed purpose of the act was to place arbitration agreements upon the same footing as other contracts. The separability rule, which the court applies to an arbitration clause, does not result in equality between it and other clauses of the contract. I had always thought that a person who attacks a contract on the ground of fraud and seeks to rescind it has to seek rescission of the whole, not tidbits, and is not given the option of denying the existence of some clauses and affirming the existence of others." Close quotes. My point here is not to criticize the separability doctrine. It is essential to the efficacy of arbitration. My point is that this familiar doctrine, adopted throughout the world, simply cannot be squared with the dominant theory that an arbitration agreement is just like any other contract. The separability doctrine, whether the product of statute or case law, treats arbitration agreements more favorably than other contracts. Let me turn to one more example of how arbitration law treats arbitration agreements more favorably than other contracts. While I'm going to focus on US law, I don't believe the approach to arbitration agreements I will highlight is unique to the United States. When it comes to the interpretation of arbitration agreements, the US Supreme Court has repeatedly held that there is a policy in favor of arbitration, and that as a result, ambiguities about the scope of an arbitration agreement must be resolved in favor of arbitration. One example is a 2019 case called Lamps Plus. But the Supreme Court first expressed this view about 40 years ago in 1983 in the Moses-Cohen case, and this proposition of law has been routinely relied on by courts throughout the United States since. In 1985, in the famous Mitsubishi case, Justice Blackmun put the point this way: as with any other contract, the parties' intentions control, but those intentions are generously construed as to issues of arbitrability. Now, let me just add a footnote there. US courts use the term arbitrability in a much broader sense than most of the rest of the world. In most of the rest of the world, the term arbitrability refers to subject matter arbitrability, to the question of whether national law might prohibit the arbitration of certain claims, the way, for example, the national law of many countries prohibits the arbitration of consumer disputes or child custody disputes. In the US, the term arbitrability relates broadly to any issue that might impact whether a case should be in arbitration. Thus, a disagreement about whether the scope of an arbitration agreement covers a particular dispute is, in US parlance, a dispute about arbitrability. Now, this core doctrine of US arbitration law, that ambiguities about the scope of an arbitration clause should be resolved in favor of arbitration, cannot be squared with the equal footing principle. After all, central to that principle is that courts should treat arbitration agreements like all others and should enforce them according to their terms. Under the law of virtually all the 50 states in the United States, when a contract is ambiguous, the typical approach of US courts is to resolve that ambiguity by considering its extrinsic evidence outside the four corners of the contract, such as the parties' negotiating history. And if US courts were truly to follow the equal footing principle, that is how they ought to approach the interpretation of an ambiguous agreement. They would consider the extrinsic evidence in order to determine the intent of the parties to the arbitration agreement. But in fact, it's not what courts do. Instead, when it comes to an ambiguous arbitration agreements, courts bypass the effort to ascertain the party's intent and simply put a thumb on the scale in favor of arbitration. This special rule for arbitration agreements has been criticized precisely on the ground that it treats arbitration agreements more favorably than other contracts. Just to quote one judge in a case called Armijo versus Prudential from 1995, the judge said, "I am troubled by the direction the case law under the Arbitration Act has taken. What was originally intended only to put arbitration agreements on the same footing as other contracts is now seen as a strong federal policy in favor of arbitrations." And he went on to say that when faced with an ambiguous arbitration clause, courts should try to resolve that ambiguity in the same way they resolve an ambiguity in any contract. They should hear evidence outside the four corners of the contract, such as the parties' negotiating history, and only if that approach failed to resolve the interpretive dispute should the court apply the rule that construes ambiguities in favor of arbitration as a last resort. But that's not what happens. The rule that requires ambiguities to be resolved in favor of arbitration is one of first resort, not last resort. Now, this generous approach to construing arbitration agreements is not confined to the United States. I don't have time to go into decisions from all other jurisdictions, but I will mention the judgment of the Singapore Court of Appeal in Larsen Oil. Judge Raja, as he then was, put the point with characteristic elegance. There are all in all strong reasons for supporting a generous approach towards the construction of the scope of arbitration clauses, given that such an approach has received widespread acceptance across the leading commercial jurisdictions and is strongly supported by the academic community. Such an approach is also consistent with this court's philosophy of facilitating arbitration. Accordingly, we agree that the preponderance of authority favors the view that arbitration clauses should be generously construed, such that all manner of claims, whether common law or statutory, should be regarded as falling within their scope, unless there is a good reason to conclude otherwise. None of this is to question the principle of law that arbitration clauses should be interpreted generously. There are good reasons for that rule, important reasons for putting a thumb on the scale in favor of arbitration. But the fundamental point is that this favorable treatment departs from the normal mode of construing contractual provisions, at least something that is very clear under US law, where a party would otherwise examine extrinsic evidence, such as the party's negotiating history, to construe an ambiguous contract. This generous approach cannot easily be squared with a theory that says an arbitration agreement should be treated just like any other contract. Which brings me to the third part of my remarks. Where does the dominant theory go wrong? In order to explain, I will begin by giving you my argument in a nutshell and then explain it in more detail. Here is my argument in a nutshell. My main thesis is that a contract, any contract, can be viewed from two separate perspectives. From one perspective, it is a private arrangement between two or more parties who agree to bind themselves in advance to certain terms. In the case of an arbitration agreement, to resolve any disputes arising out of or relating to a contract by arbitration instead of in the courts. From this private perspective, an arbitration agreement is indeed just like any other. From another perspective, what we might call a public law perspective, a contract implicates both national law and public institutions such as courts. Thus, contracts always operate in the shadow of national law, which might set forth rules governing who has the capacity to enter into a contract, whether any formalities are required, whether particular terms are unenforceable, and so on. And of course, one important aspect of any contract is that a party has a right to seek relief from the courts in the event that the other party breaches it. And from this standpoint, the public law standpoint, an arbitration agreement is differently situated to any other contract. Why do I say that? Let me elaborate by beginning with the first perspective that views a contract as a private arrangement. While every contract is a private arrangement, not every private arrangement is a contract. After all, there are many private arrangements, a romantic relationship, a book group, a friendship, but not all these private arrangements have legal implications. What distinguishes a contract from just any private arrangement is that it creates legal rights and legal obligations. And while most of the time parties generally abide by their contractual obligations, an important distinguishing feature of a contract is the ability to seek relief from the courts if the other party fails to abide by its terms. Which brings me to my main point. While an arbitration agreement is the same as any other contract when viewed from a private standpoint, as parties exercising their autonomy to resolve their disputes by arbitration instead of in the courts, it is different when viewed from a public standpoint as an agreement that can be enforced in the courts. Let me explain why by giving a hypothetical example. Imagine an art dealer here in New York, where I am right now, sells me a painting. I pay him, but he doesn't deliver it. I sue him in court for breach of contract, and I seek damages and/or specific performance. We have a private arrangement, a contract to buy and sell a painting. The art dealer doesn't live up to his obligations, so I enter the public realm and I seek relief from the courts. And my going to court means that I now have the potential to invoke the coercive power of the state to enforce my bargain. If I win in court and he still doesn't pay, I can compel him to do so by freezing his bank accounts or seizing his assets. And if I obtain the remedy of specific performance, he can be compelled to deliver the painting to me under threat of being held in contempt of court. Now, it is the rare contract dispute where a party has to have recourse to the courts to enforce it, and rarer still is the case where a party has to deploy the coercive power of the state to enforce its terms. Most people abide by their contractual obligations, and most people who lose in court prefer to obey a court order rather than have assets seized or risk being held in contempt of court. But the possibility to go to court is always there, and it is this possibility that creates the culture of compliance with contracts. The ability to go to court to enforce a contract is essential to the efficacy of all contracts, including arbitration agreements, and is essential to upholding party autonomy. Now, of course, no one wants to be in court. It's a huge inconvenience. It costs money, takes time, it is uncertain. But the fact that there's a right to go to a court to enforce a contract is an important reason why parties comply with their contractual obligations. Let me change the hypothetical in just one way. Supposing this time there's an arbitration clause in the same contract, an agreement that if we have any disputes about the sale of the painting, we will resolve them in arbitration instead of in the courts. Otherwise, the facts remain the same. I buy a painting from an art dealer in New York, I pay him, but he doesn't deliver it. This time, instead of going to court, I commence an arbitration. But imagine the art dealer ignores the arbitration agreement and simply fails to appear, or fails to nominate an arbitrator, or fails to take any step in the proceeding. Or suppose that before I even get a chance to start an arbitration against me, he sues me in court for a declaration of non-liability. Or suppose I commence an arbitration and I prevail, and I'm awarded damages or specific performance, but he doesn't pay the damages award or doesn't deliver the painting. In all these cases, the art dealer is in breach of his contractual obligations under our agreement, in the same way he might be in breach of any other contractual term. And just as is the case with any contract, if a party fails to live up to its obligations under an arbitration agreement, I have the right to go to court to seek relief. Indeed, it's a right embodied in Article 2.3 of the New York Convention. Similarly, if I prevail in an arbitration proceeding, but he doesn't abide by his obligations under an award, I have a right to go to court to require that he complies. This is a right embodied in Article 3 of the New York Convention, subject to the defenses in Article 5. Just as the right to go to court to enforce a contract is essential to the efficacy of all contracts, so it is for arbitration agreements. There would be little point in agreeing to arbitrate if you couldn't enforce an arbitration agreement or award. Indeed, that's the entire purpose of the New York Convention, to make sure that arbitration agreements and awards are enforceable in courts across the world. But going to court to enforce an arbitration agreement or arbitration award is very different to going to court to enforce any other contract. Why? Well, when it comes to any other contract, to be sure, and as I said, no one, except perhaps a lunatic or a fanatic, wants to be in court. It takes time, it costs money, it is uncertain. When it comes to going to court to enforce an arbitration agreement or an arbitration award, it is, of course, all those things. But there's one critical difference. My entire rationale for agreeing to arbitrate is to resolve disputes in arbitration instead of in the courts. But when a party fails to live up to its obligation under an arbitration agreement or award, here I am having to invoke the very judicial process I wanted to avoid by agreeing to arbitrate in the first place. My need to go to court to enforce an arbitration agreement or arbitration award, while necessary to the efficacy of the arbitration process, is also fundamentally inconsistent with my rationale for agreeing to arbitrate. Which brings me to the critical point. The run-of-the-mill court involvement, essential to ensuring the efficacy of any contract, can, in the case of an arbitration agreement, undermine or displace the entire arbitration process altogether. If parties to an arbitration agreement find themselves in lengthy or costly court proceedings just to get an arbitration off the ground, or just to enforce an arbitration award, the entire rationale for that process is undermined. arbitration agreements are different from other contracts because they face a predicament that no other contract faces when a party to it has to seek relief from the courts. The precise court involvement necessary to the efficacy of all contracts could operate to displace arbitration altogether if it is too intrusive, too time-consuming, too costly, too uncertain. Let me explain this point another way. Imagine courts didn't enforce arbitration agreements or arbitration awards at all. In such a world, there would be little point in agreeing to arbitrate, since there would be no way to compel the other party to live up to its arbitration obligations. Arbitration would likely fade away because it would be toothless. From this standpoint, arbitration needs the assistance of the courts. Court involvement in arbitration is essential to the efficacy of arbitration, critical to upholding party autonomy. But if this precise court involvement were too intrusive, too costly, too time-consuming, the result would be the same. Arbitration would fade away because it would be pointless. Just as no one in their right minds would sign an arbitration agreement if he or she had no ability to enforce that agreement or any subsequent award in the courts, so no one in their right minds would sign an arbitration agreement if the enforcement of that agreement or award involved full-scale litigation. Rather than choosing to resolve their disputes in arbitration instead of in the courts, they would be committing themselves to resolve their disputes in arbitration in addition to the courts. To summarize, therefore, an arbitration agreement differs from any other contract because it faces a predicament that other contracts simply don't face. The court involvement essential to the efficacy of all contracts, if too intrusive, can displace arbitration altogether. It is this difference that explains why we cannot treat an arbitration agreement just like any other contract, but instead need in some instances to treat arbitration agreements more favorably than other contracts, to have special rules designed to limit court involvement in the arbitration process to avoid undermining it altogether. These special rules include the separability doctrine and a generous approach to the interpretation of the scope of arbitration agreements. The separability doctrine does this by providing that where there is a challenge in court to the validity of a contract containing an arbitration clause, a court need not undertake the time-consuming and fact-intensive task of determining its validity, but rather send the case straight to an arbitrator, which brings me back to the rationale the majority offered in Prima Paint for its adoption of the separability doctrine, which are words I said I'd come back to. The court said that the point of the separability doctrine was to ensure, quote, that the arbitration procedure, when selected by the parties to a contract, be speedy and not subject to delay and obstruction in the courts. The separability doctrine ensures that parties don't get bogged down in court just to get an arbitration off the ground. The same rule applies to the rule. The same also applies to the rule that provides that any ambiguity in an arbitration clause should be resolved in favor of arbitration. If that wasn't the rule, in the US at least, a court would have to consider extrinsic evidence, that is, evidence outside the four corners of the contract, to resolve any ambiguity. That might involve a trial, where a court or a jury would hear evidence about the parties' negotiating history before a determination was made as to its scope. But having a rule that in essence places a thumb on the scale in favor of arbitration, a court can bypass what is potentially a fact-intensive and time-consuming process and send the case straight to arbitration. Now, the separability doctrine and the rule that provides for the generous construction of the scope of arbitration agreements are just two rules that courts have adopted to try to balance providing sufficient involvement for arbitration to assure its efficacy, but not so much as to overwhelm it altogether. In the US, many doctrines designed to provide this balance are justified in the name of the federal policy in favor of arbitration, which, as I said earlier, was announced by the US Supreme Court for the first time in 1983 in the Moses Cohen case. I won't go into the facts in any detail, as it involved a complicated interplay between state and federal courts that you sometimes see in the United States. But that case, in essence, involved a federal court that declined to compel arbitration. It stayed consideration of an application to compel arbitration. And the court said that this decision of the lower court not to compel arbitration was, quote, plainly erroneous in view of Congress's clear intent in the Arbitration Act to move the parties to an arbitral dispute out of court and into arbitration as quickly and easily as possible. And the court went on to state that in determining whether a case belonged in arbitration, a court should undertake an expeditious and summary hearing with only restricted inquiry into factual issues. Courts in other countries have similar principles. Singapore courts, for example, invoke a principle of minimal judicial intervention, which is very similar to the notion expressed in US cases of getting disputes out of court and into arbitration as quickly and easily as possible. The rationale for this principle finds expression in the judgment of the then Judge Raja in the Tijong Very Sumito case. He said, "The whole thrust of the IAA is geared towards minimizing court involvement in matters that the parties have agreed to submit to arbitration. Concurrent arbitration and court proceedings are to be avoided unless it is for the purpose of lending curial assistance to the arbitral process. Jurisdictional challenges must be dealt with promptly and firmly. In short, the role of the court is now to support and not to displace the arbitration process." And in the recent case of COT versus COU from October of this year, Judge Chong echoed this point by quoting the felicitous words of Michael Huang, that Singapore's, quote, minimal intervention policy reflects the expectations that courts should supervise with a light touch, but assist with a strong hand. Thus, courts must strike a balance between sufficiently involved to ensure that the arbitration process is workable, but not so involved that they overwhelm arbitration altogether. And the arbitration law of any country can be viewed in terms of how it strikes this balance. And different countries often strike the balance differently in ways I don't have time to get into in my remarks. Let me turn to part 4 of my remarks, where I will add 2 nuances to my argument. My main thesis up to now is that arbitration agreements face a predicament that other contracts simply do not face, which is that the court involvement essential to the efficacy of all contracts can, if it is too intrusive, displace arbitration altogether. There is a second way in which arbitration agreements differ from other contracts that compounds this predicament. Unlike the case with contracts generally, where there is one primary potential occasion for court involvement in a dispute about the contract itself, has it been breached? Was there an anticipatory repudiation? When it comes to arbitration agreements, there are 3 potential occasions. Thus, there can always be a dispute at the inception of the arbitration process where a party, for example, breaches an arbitration agreement by commencing litigation on a dispute subject to arbitration. But there are 2 more occasions where courts can get involved in an arbitration. This is because, first, an arbitration agreement contemplates a process, an arbitration proceeding, that itself may implicate court involvement. And second, this process may yield an arbitration award, which also might give rise to proceedings in court. As a result, there are actually 3 potential occasions where court involvement might be necessary to assist the process, but at the same time, if too intrusive, might threaten to displace it. And similar principles apply to those that apply to limit court involvement at the outset of a dispute, such as the separability doctrine or the generous approach to interpreting arbitration clauses. These similar principles apply at these other stages of an arbitration process. Thus, courts almost never intervene in an ongoing arbitration other than to provide support, for example, to assist in the taking of evidence or to grant preliminary relief or to appoint a replacement arbitrator if the rules don't provide for that. Thus, in most countries, you can't go to court in real time and complain about the conduct of an arbitration. You have to wait until the end. Similarly, while courts are entitled to review arbitration awards at the end of the case in actions for vacatur, the scope of review tends to be very narrow, with the aim of avoiding too much court involvement. Here is Justice Kagan again from the Oxford Health Plans case from 2013. She said, under the FAA, Federal Arbitration Act, courts may vacate an arbitrator's decision only in very unusual circumstances. That limited judicial review maintains arbitration's essential virtue of resolving disputes straight away. If parties could take full-bore legal and evidentiary appeals, arbitration would merely become a prelude to a more cumbersome and time-consuming judicial review process. Singapore courts take a similar approach. In BELC versus BLB, the court said that the same generous approach used to construe an arbitration agreement should also apply to the review of an arbitral award. In BLC, the court outlined the approach in this way. In short, the court is not required to carry out a hypercritical or excessively syntactical analysis of what the arbitrator has written, nor should the court approach the award with a meticulous legal eye, endeavoring to pick holes, inconsistencies, and faults in awards with the objective of upsetting or frustrating the process of arbitration. Rather, the award should be read in a reasonable and commercial way, expecting, as is usually the case, there will be no substantial fault that can be found with it. This brings me to the second point I wish to make. So far, I've focused on party autonomy. I now want to say a word about legitimacy. For not only is court involvement essential to ensuring that party autonomy is upheld, but it is also important to ensure that the process operates legitimately. Given the limited time I have, I just want to offer one example. One of the more interesting questions that arises in arbitration law is whether or not parties by contract can narrow or even eliminate altogether the grounds on which a court at the seat can set aside an award. For example, can they include in their arbitration agreement a provision along the following lines? The decision of the arbitrators shall be binding and conclusive upon each of the parties hereto, and shall not be subject to any type of review or appeal whatsoever. That was the language in an arbitration clause from the US case called Hobbes versus MVL Group. And you would think perhaps that given a central aim of arbitration law is to promote party autonomy and to minimize court interference in arbitration, a court considering such language would welcome it with open arms and immediately dismiss an action to set aside an arbitration award on the grounds that the parties eliminate judicial review. Now, when you view an arbitration agreement as simply a private contract, that might make sense. You are respecting party autonomy. The parties have chosen not to have any review of the award at all. By enforcing an arbitration award without any review, you are reducing court involvement to a bare minimum. But this overlooks the public law perspective on arbitration. As I mentioned, once a party enters the public realm and requests relief from the courts to enforce an arbitration agreement or award, the coercive power of the state is potentially implicated, with the award creditor being able to seize assets or freeze bank accounts, and so on. And so it is reasonable to ask whether that deployment of state coercive power, which may follow from an arbitration, is legitimate, which of course it would not be if, for example, the arbitration process that led to an award suffered from some serious due process irregularity. In this way, party autonomy expressed in an agreement to eliminate judicial review of an arbitration award at the set-aside stage could conflict with the legitimacy of the process if that process was tainted in some way. Courts in different countries may resolve that conflict differently, but in this case, the US court declined to enforce the provision that purported to eliminate judicial review of an arbitration award altogether. Why? Precisely because while an arbitration agreement is a private contract, it can implicate the coercive power of the state. Here's what the court said. An agreement that contemplates confirmation but bars all judicial review presents serious concerns. Arbitration agreements are private contracts, but at the end of the process, the successful party may obtain a judgment affording resort to the potent public legal remedies available to judgment creditors. In enacting Section 10 of the Federal Arbitration Act, and that is the provision that sets forth the grounds for set-aside, Congress impressed limited but critical safeguards onto this process, ones that respected the importance and flexibility of private dispute resolution mechanisms, but at the same time barred federal courts from confirming awards tainted by partiality, a lack of elementary procedural fairness, corruption, or similar misconduct. This balance could be eviscerated and the integrity of the arbitration be compromised if parties could require that awards flawed for any of these reasons must nevertheless be blessed by federal courts. One lesson from this is that the values that are central to arbitration of autonomy and legitimacy sometimes conflict. And when courts get involved in arbitration, part of their role is to ensure that the process is legitimate, that the parties are not required to comply with arbitration awards when they did not consent to arbitrate, when the arbitration process suffered from a due process irregularity. With that, let me conclude my remarks. My hope is that in thinking about the ways in which an arbitration agreement is not like any other contract, we can better understand our arbitration law and ensure we have in place the doctrines and rules that best promote party autonomy and the legitimacy of the arbitration process. Thank you.
Thank you, Mr. Fallis, for that insightful lecture. We will now have the panel discussion. Just a gentle reminder that you may send your questions to the panelists using the Q&A function. As we have limited time, the panelists will try their best to answer as many questions as possible. The panel today will be moderated by Mr. Ankit Goyal, partner at Allen & Gledhill, and the panelists are Mr. John Fallis, full-time arbitrator at Fallis Arbitration, Mr. Aditya Singh, YSIC council member and partner at White & Case, and Ms. Melissa Thim, partner and co-head of international trade practice at Dentons, Rodite & Davidson. I'll now hand the time over to our panel. Mr. Goyal, please.
Thank you, Hannah. John, perhaps you should get a glass of water. There was
I have one right here.
superb. And not to forget the fact that this is slightly early in the morning, to be euphemistic about it. But I thought that was an intriguing and fascinating talk, delving into a topic so fundamental to arbitration, yet almost completely, if not very much, overlooked. So what we are aiming to do over the next course of the next 30 minutes, we will look at the genesis of John's comments, look at how those comments are probably a cause of concern in this part of the world. How have some jurisdictions over here looked at similar issues? I mean, at the end of the day, courts all over grapple with the idea of court assistance versus court interference. When is it that when you put a thumb on the scale in favor of arbitration become not much or maybe a bit too much? So it's that sort of balance that is imperative and important to understand. We will, of course, talk a little bit about the court's approach in this region on how they've looked at arbitration agreements. But before we do that, John, and coming to the point that this is often overlooked, I think we were all curious to get to understand what got you interested in this topic that you've addressed. Give us a bit of a sense of where this sort of arose from and the background to that.
Sure. Actually, what really got me focused on thinking about this question was the decision in the Morgan versus Sundance case that I mentioned actually at the outset. And what the court said in that case, and I didn't really go into it in the beginning of my remarks. In fact, let me just sort of perhaps back up a little bit. You know, as is perhaps apparent from my remarks, there are these sort of two competing principles that reside in US arbitration law. One is this same footing principle, a contract is just, an arbitration agreement is just like any other contract. And one is the federal policy in favor of arbitration that has been used to justify all sorts of arbitration favoring rules in the United States. And these two principles, in a sense, have resided side by side, living together, sometimes in tension, but generally, you know, used appropriately. Sometimes courts rely on one, sometimes on the other. What happened in the Morgan versus Sundance case is the court said, and I just want to get the language right, it in a sense rejected the federal policy in favor of arbitration. It said that the Federal Arbitrations Act policy in favor of arbitration does not authorize federal courts to invent special arbitration preferring procedural rules. It said frequent use of that phrase connotes something different. That policy is simply an acknowledgement of the commitment to overrule the judiciary's long-standing refusal to enforce arbitration agreements and to place such agreements on the same footing as other contracts. And it got me very concerned when I read that. This is a decision of the unanimous US Supreme Court saying, essentially, we can't have any special arbitration favoring rules. And I think it was an unfortunate overreach by that court to say that, because I don't think, you know, the court had really considered the implications of that statement. But it really then got me thinking, you know, everybody says an arbitration agreement is like any other contract. That is what the Supreme Court just said. That is the rationale they offered to reject the notion that there should be special rules favoring arbitration. And it just really got me thinking, actually, is an arbitration agreement just like any other contract? And that's really the genesis of my remarks. I'm sure we can talk more about the Morgan case and about subsequent developments since the Morgan case, because there has been at least one Supreme Court decision where they did actually create a special rule for arbitration, but we can get to that.
No, thanks, John. You know, the implication of the US Supreme Court's decision can have far-reaching consequences. I mean, in the context of what you've discussed, John, specifically in relation to court-created principles of separability in the US, or the fact about generous interpretation of arbitration agreements, these are fundamental, if not central, to the existence of arbitration. And as you rightly said, arbitration cannot but exist in a vacuum, and it needs court support. And therefore, you know, one of the first questions that sort of comes up, and you know, Aditya, maybe I'll ask you first this: is this a US problem? Is this something that, you know, we should be in this part of the world be concerned about? Is there something relevant that is probably, you know, from your experience of having studied and worked in US, you know, something that you want to share? Maybe John has a few points to make about that as well. But just curious to understand where this may be coming from, where Justice Kagan may be wanting to take the thumb off the scale a little bit. Any thoughts?
Sure. So look, I do think, to answer your question very quickly, yes, I do think it is a US problem, and I'll explain that, right? First of all, thank you, John, for that wonderful and thought-provoking lecture. And in thinking about your lecture and the Morgan decision, right, the question I ask myself is, why is it that the court has ruled the way that it has? What might explain the US Supreme Court thinking the way it's thinking at a time when courts in most other sophisticated jurisdictions are in a race to be seen as pro-arbitration, right? And here is one possible explanation. For those not familiar with the US Supreme Court, the court hears only about 80 cases in a term. And almost all the issues that it chooses to grapple with are political to some degree, right? And I would suggest that we can better understand what the court is doing here if we look at this issue through a political lens, right? Arbitration in the US is a lot more controversial than it is in any other jurisdiction I can think of. I'm happy to be corrected, but I don't think in any other place it's as controversial. And this is in large part a function of this beast called mandatory arbitration, which is where businesses require employees or consumers to agree to arbitrate disputes rather than going to courts. And there has been significant criticism in the US of mandatory arbitration in consumer contracts and employee contracts. And you'll find thousands of articles and op-eds by passionate critics of arbitration who argue that sort of the neoliberal roots of the arbitration revolution have diminished access to justice for millions of people. I mean, that is literally the language that is used in some of the commentary. And on top of this, right, in the last few years, a few more things have happened that have made arbitration in the United States a bad word. It's become a bad word, right? First, there has been some alarm that companies are trying to restrict shareholders' access to enforce securities laws via arbitration. Second, in the wake of the Me Too movement, the US Congress passed a law that was called Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. And this legislation, which had bipartisan support, essentially forbid clauses in employment contracts requiring workers to arbitrate sexual harassment and abuse cases, right? And this is a legislation that has retroactive effect, nullifies any mandatory arbitration clauses in contracts that have already been signed. And third, and how can we forget this, right? The political backlash against investment arbitration a few years ago, led in a sense by Senator Elizabeth Warren, who wrote, an article in the Washington Post saying, investment arbitration, it sounds very mild, but don't be fooled by it because it will tilt the playing field in the favor of big bad multinational corporations. And a number of people then joined her, and for the first time, legitimacy of international arbitration was being questioned in the mainstream media and not just in arbitration conferences and seminars. So what all of this, I think, has done is that it makes large sections of opinion makers and legal thinkers in the US queasy when they encounter arbitration. And it should not surprise us that this has negatively impacted how they view commercial arbitration as well. The pot was boiling for a long time. And I'll end with this on my first sort of set of remarks about what John has said. Arbitration in the United States is significantly more controversial when you find individuals pitted against companies, right? You have members of Congress, political activists, judges, developing a sense of unease when an individual is pitted against a corporation in an arbitration. And in this context, I would urge you to think about the facts of the Morgan versus Sundance decision, right? Morgan was a lady called Robin Morgan. She was a worker at a Taco Bell in Iowa, which was owned by Sundance. She used to get hourly wages. Okay, she was paid by the hour. She and her fellow employees discovered that Sundance had been manipulating her and other employees' time records by moving hours from one pay period to another to essentially ensure that the threshold for overtime never got triggered. And so she ultimately bought a wage theft lawsuit under the Fair Labor Standards Act, and Sundance moved to compel arbitration under the FAA. There was a bunch of litigation, and that's how the matter landed before the US Supreme Court. And I think this specific factual context and the broader feeling about arbitration gives us an insight into why, in the words of Carla Gilbride, who was counsel for Morgan in the US Supreme Court, the Supreme Court has struck a blow against arbitration exceptionalism, as she calls it, right? And I think that sort of helps us understand this a little bit. But very interested to hear what John has to say about this.
Yeah, thanks, Aditya. I'm sure you, John, have some views on Aditya's thoughts about where this is coming from.
Yeah, I mean, I agree with everything that Aditya just said, and let me just perhaps make a further point. This is because I don't want to repeat, because I agree with everything he said. The further point is that one of the interesting things about the United States is it has an arbitration act that has been virtually unchanged for almost 100 years. Here we are England's about to pass a new arbitration act, approximately 30 years, less than 30 years after the 1996 act. I think it may be passed this year or early next year. One of the reasons the US Arbitration Act has not been reformed, or there's been such difficulty in reforming it, is that there are just such different views on it. You know, from the standpoint, big business companies like arbitration because it takes cases out of the court, and as I'm sure you all know, in US courts, civil cases can be resolved by a jury. And it has also been construed recently, the arbitration law, to enforce what are called class action waivers. So, you know, in the United States, you have a right to bring a case as a class action in the court. Class actions are big and they're very threatening to companies. What has happened is, big corporations, especially in consumer contracts, employment contracts, can often put an arbitration clause in a contract with what's called a class action waiver. I agree to arbitrate and I waive my right to bring a class action. Those have been enforced. And lawyers who typically represent plaintiffs, they hate arbitration. On the other hand, big companies like arbitration. And so, there's been very little consensus on trying to reach reform of the act. It just sort of maintains it's stuck in this place of stasis, really. The only, and Aditya touched on this, one of the few ever amendments to the Federal Arbitration Act was made in 2021. It was the product of the Me Too movement, and it did, bar arbitration for sexual harassment claims, and that was in the wake of what happened in the Me Too movement, and the theory being that women were harassed, and you would have these serial harassers who would manage to have everything in arbitration with an NDA, so it never came out publicly. And that was the impetus for that change. It's really been the only change. In a lot of countries in the world, for example, consumer disputes are not arbitrable throughout most of the EU. Not in the US, they're arbitrable.
Yeah, fascinating. I mean, I think very helpful Aditya to get that view from a political standpoint, how arbitration is sort of gone through over the years. But I think, John, what you mentioned about the arbitration legislation in US, I think is the real indication of the challenge that we are facing and the reason why probably this issue piqued your interest. And I think to that, I want to turn to Melissa now. I mean, obviously in this part of the world, Melissa, we're talking about UNCITRAL students. We're all UNCITRAL arbitration law junkies. And from our perspective, when we talk about separability, we look at, Article 16 codified in law. When we talk about generous application of arbitration agreements or court support in arbitration agreements, we're always looking at the provisions under the model law, which either are part of the Indian Arbitration Conciliation Act or the fact that they're part of the IAA, one way or the other. And unlike the US, John, you mentioned about the law being there almost 100 years ago, barring very few amendments. I mean, the Singapore legislation has gone through a fair amount of, additions, subtractions, edits, amendments, just to keep it, in line. So here's a question for you, Melissa. I mean, should we be concerned about Morgan versus Sundance? What are your views in terms of just the Singapore court's approach on how they've looked at arbitration? Curious to hear your thoughts, Melissa.
Thanks, Ankit. So I think the model law definitely helps. The fact that Singapore has adopted the model law means that we have a very basic acceptance of the principles set out therein. But it's also only the basic starting point. I'm sure everybody here is familiar with the fact that not all model law countries approach the application of these rules in the same way. What sets Singapore apart traditionally is the fact that the courts, as John has said, have repeatedly affirmed the position that Singapore adopts a pro-arbitration stance. The courts have expressed this by reference to the policy of minimal curial intervention, a policy of respecting and preserving the autonomy of the arbitral process, as well as describing the court's role as merely to support arbitration rather than to interfere. So we also do not have the same policy issues described by Aditya that affect the US courts. In Singapore, generally speaking, the government policy goes. And insofar as that is a pro-arbitration one, the courts have adopted and run with it. But at the same time, when we initially had this discussion with John, and I had occasion to really think further about the reasons for this policy and whether or not the courts actually have a preferential a stance towards arbitration, I am not sure if we really do have a strongly pro-arbitral stance. There are very many aspects of the court's approach to enforcing arbitration agreements and awards that are very well rooted and sensible when seen in the light of our usual general contractual principles. And that's something I thought I would raise today. And I'll illustrate this with reference to two examples. One, the Singapore approach to arguably pathological arbitration clauses. And two, the adoption of the prima facie standard when it comes to when the courts approach applications for stay of proceedings in favor of arbitration. On the first point, I think Singapore has long been regarded as having a very generous view when enforcing arbitration clauses. In our case of In Sigma, which I'm sure everybody is familiar with, the Singapore court enforced an arbitration clause which provided for arbitration to be under the auspices of the SIAC, but pursuant to ICC rules. This is not a clause that would be enforced in every other jurisdiction, even model law jurisdictions. And arguably, there's no reason for such a clause to be enforced because the general contractual principle is that a clause that's uncertain, vague, impractical, may not be enforceable. However, the Singapore court rationalized that this court was enforceable with reference to the principle of effective interpretation, which essentially asked the court to place focus on the fact that the parties had, by reference to the express words of the clause, expressly chosen to arbitrate rather than litigate, and the courts should work towards making that agreement effective. So for that reason, the courts have, in a sense, filled in some of the blanks, or arguably took a more generous approach to ensuring that this clause is upheld so that the parties' contractual bargain of arbitration was respected and honored. In a more recent case of Shanghai Xinwall, the court found that a clause which provided for arbitration in the China International Arbitration Center was also enforceable for a similar reason. There's no such institution, but the court rationalized that parties would not have intended to refer to a non-existent institution, but one that was simply a mistake of name. And the court's role was actually to determine whether parties intended to refer to the same institution, a different institution, or if it was so truly vague that no one could tell whether there was any agreement or not. Upon this analysis, the court determined that parties did in fact intend to refer to CTAC, and for that reason enforce the clause. So I would say that when you look at these two cases on a very superficial level, it seems to be examples of the court stretching its enforcement powers to find an agreement to arbitrate when there was none. But when viewed in the light of principles of effective interpretation, it's not such a stretch. The court is simply giving effect to what parties expressly agreed to, which is to arbitrate rather than litigate. And the courts have, in doing so, placed focus on the greater injustice that would be imposed on parties who had entered into that contractual bargain, but then somehow found themselves in court, which is precisely the point that I think John was trying to make when talking about the interplay between the private and public spheres. My second example would be the court's approach to stay court proceedings in favor of arbitration. Singapore adopts a prima facie approach to this issue, which represents a departure from some of the approaches in other jurisdictions, where the court would have to determine the existence of an arbitration agreement or its validity on the full balance of probability scale. In Singapore, the courts take a somewhat more broad brush prima facie approach. And so long as there's a prima facie evidence of an arbitration agreement, they would ask the tribunal to determine the issue of validity at first instance. Again, this would superficially seem to be the court giving arbitration clauses preferential treatment. But in fact, this is, I would argue, a natural consequence of the court respecting parties' agreement to arbitrate, and also recognizing that the principle of competence has been adopted as part of our national law. There's no way that this principle would have its force and have teeth if a court were allowed to determine at first instance whether or not arbitration agreement existed. And it would only encourage parties to try to bring disputes in court if they wish, and have the court determine the issue of whether there was an arbitration agreement, and in fact erode parties' primary agreement to arbitrate completely. I see that I am running out of time, so I might just end here, and I'll leave it to turn it back to Ankit.
No, thanks, Melissa. I think both of those were very apt observation in terms of how the Singapore courts have looked at this issue, and I think those comments are very helpful. I mean, I think one of the things is that a lot of our audience today is joining from India, and while India had in fact codified the unsettled model law in 1996, to the point that Melissa you made about incorporation or adoption of model law does not mean a homogeneous interpretation of it. And I think that would be very much true in the case of India specifically, because Indian courts and arbitration have had what one may call is a bit of a tumultuous relationship, a bit of a up and down, rocky road, one may even say. But question to you, Aditya, what are your views, in terms of how Indian courts have looked at arbitration? And are there any indication that the Indian courts are now moving towards regaining lost ground? Is there any cause for concern of the similar kind that John has highlighted?
Thanks, Ankit. So look, our audience from India will remember that the Indian arbitration landscape, as you said, has had a troubled history, right? I think well until maybe 2012, Indian courts had a bad rep for being too intrusive, not respecting the integrity of the arbitral process. And, together with its dated legislation, India was well known as an arbitration unfriendly place. And I think in 2012, and that I consider as the tipping point for Indian arbitration, you had the decision in Balco, really encouraging courts not to intervene in foreign seated arbitrations. And there have been, over the last decade, several other decisions which have cemented, India's pro-arbitration stance. And we don't have the time to go over the details, but there is a long list. And while there are a few aberrations once in a while, I frankly see very little risk that Indian courts would move in the direction of the Morgan court, right? And the reason for that, and I apologize for being a bit crude, is that we're a ways away from the US, right? The US can afford such setbacks to its arbitration law. India is a growing economy, a predominantly capital importing country. It needs foreign investment, and everyone understands that, right? It doesn't do well in the World Bank's ease of doing business rankings. And, the lowest scores are always on contract enforcement. And there's a conference a week in Delhi, Bombay, or Bangalore, where, you have judges being called on to take a more pro-arbitration stance. There is sort of subtle messaging from the higher judiciary. There's legislative reform. So with all of this going on, right, I see very low risk of courts trying to regain any ground from arbitration. That's
a very fair point, Aditya. In fact, you will remember this, once that White Industries decision came across against India, the new government came in 2014, and it almost became one of their mantras to say, look, we want to be an arbitration-friendly jurisdiction. But I think one of the key issues in India that we often face, John, is the fact that there is no, or at least the concept of institutional arbitration has not taken off. And that comes in inherently from the perspective that when you have to go to court for appointment of arbitrators, it is very much in the hands of any party to say there is no arbitration agreement, or I'm raising questions about the arbitrability of the dispute, which then really raises those questions. I've not been told to do so, but a plug for the SIAC and for the vast audience that's joining, that if you do have institutional arbitration and have an SIAC clause, go to the SIAC website and get a model clause, you would probably not have those challenges, that you would come across in terms of court involvement. Just one final point before I leave India. One of the participants who was going to be attending this talk, Aditya, sent across a very interesting case to me, which was rendered by the Supreme Court, which included the Chief Justice of India in November last month. And it basically, the question before the court was that whether pre-deposit as a condition, which was part of the arbitration agreement, is okay. And the court said that the condition of having a pre-deposit was arbitrary, and it said that it was contrary to Article 14 of the Constitution of India. When I looked at that decision, John, it really brought me back to that public sphere, where arbitration exists. And what the court did was looked at the Kelsen theory of law and talked about the hierarchical order. And it said that, look, even though arbitration exists in a private sphere, it should really still conform to what is really the order of law or the norm, as it's said. I mean, of course, we don't have the opportunity to discuss that further, but I thought it was of interest and probably relevance. For anybody who's interested to look at that decision, the name of the case was Lombardi Engineering versus Uttarakhand Jal Vidyut Nigam. It's a Supreme Court decision. If anybody's interested, can have a look at it. I see that we've gotten a few questions. One of the questions I thought I'll put to you, John, and maybe Aditya, you can share some views on this as well. One topic of discussion in relation to enforcement of arbitral awards is this concept of, what we call territorial versus transnational, local versus delocalization of arbitration. I mean, essentially, the concept is plainly put is an arbitration award or an arbitration is transnational, such that even if the award is set aside at the seat, you could still enforce it in other places. Are we going too far, John? What are your views, and how does that sort of mesh into what you discussed? Your thoughts, maybe Aditya, you can also give further color to that point.
Sure. I mean, let me answer that perhaps in two ways. First, what I have to say to some extent is neutral as between the two sides of that debate, as between the territorial and the transnational side. I think even those who take the transnational view that an award set aside at the seat, they still say it has to be enforced somewhere. You still have to go to court to enforce it somewhere. The notion that an arbitration award exists just in the abstract, which is, I think, in essence, what the transnational view holds, that notwithstanding it's set aside at the seat, it nonetheless has existence. It's all well and good, but unless it's enforced somewhere, it has no meaningful impact on the world. So, my point is simply about court involvement in arbitration, and I think what I have to say is consistent with both sides on that. Moving aside from that, I mean, my personal view on this debate is, I actually here tend to follow the view. I think the U.S. courts have a middle ground, which I think is a good middle ground, which effectively says whenever a U.S. court is faced with an award that was vacated at the seat, the U.S. court is now faced with two conflicting obligations. One is its discretion to enforce under the New York Convention. The other is its obligation to enforce an award rendered in another country. And those obligations sometimes can conflict. U.S. courts tend to be very generous in enforcing foreign judgments. So, and in a sense, a decision setting aside an award at the seat is a foreign judgment. It's a judgment of a foreign court setting aside at the seat. U.S. courts would generally respect any foreign judgment, but there are some exceptions. If due process was violated, if the losing party got no notice, if the judgment of the foreign court was fundamentally unjust in some way. That's actually why you see U.S. courts. Sometimes they enforce awards set aside at the seat, and sometimes they don't. And it's not an absence of principle. There is a principle. There is sort of, a rationale for the decisions. It's just that this conflict between the New York Convention and the obligation to enforce a foreign judgment subject to certain defenses just resolve themselves differently in different cases. But it is personally how I see that debate, and it's perhaps a middle ground between the two different positions.
Yeah, I think, John, you've said everything I think there is to be said on this. I'll just say that, in preparing for this, reading John's lecture and reading other literature around the theory of international arbitration, I came across a very interesting quote in Jan Paulsen's text, The Idea of Arbitration. And I think he really captures this fundamental dilemma quite well. Just a line, he says, I quote, "The great paradox of arbitration is that it seeks the cooperation of the very public authorities from which it wants to free itself." And I thought this was really interesting, right? Because it demonstrates again that the challenge is to find the right balance. And I think that is what John's lecture has so beautifully sort of encouraged us to think about.
That is absolutely correct. I mean, we are informed that there are 5 minutes left, and notwithstanding the fact that we've had a couple of hours now, John, just credit to how interesting the audience has found this. We still have several hundred, if not as many people who joined still sticking on. I have received a couple of questions. One question which we have endeavored to sort of cover in relation to the enforcement of arbitral awards. And I think safe to say, just to close off that question, you still need the court's powers to enforce the award. We are still some distance away from suggesting enforcement mechanisms where independent institutions like the SIAC get involved in enforcement. So I think it's safe to say that we would proceed on that basis to say court involvement will be there. And John and Aditya have shared some thoughts in relation to what happens if an award is set aside at the seat, what happens to the award if it comes to enforcement. One of the questions that has come up, and I don't know, John, if you had a view on this, the audience participant has asked a question about, should the arbitration process be more tailor-made? I think they're talking about the fact that if we want arbitration to be more prevalent in newer areas like insolvency and IP, is it important, might not having tailored forms of arbitration without departing from most core principles be a good idea, and in fact be essential for arbitration's legitimacy? I'm not sure if it's a topic that deals more with legitimacy, but it deals more with arbitration's proliferation in dealing with topics which are otherwise not dealt with. But just a question to you, John, coming from where you're coming. And I think one of the themes that we picked up in the course the last hour and a half is, has arbitration taken a bad name, to take a leaf of what Aditya spoke about, in the US, because many disputes have become arbitrable? And is there such a thing as a balance, not only what the courts have to sort of perform, but also the arbitration community, or should I say the commercial community, has to sort of endeavor towards to say, well, you know what, some disputes are just not okay for arbitration, because once you go down that path, it may as well be a slippery slope, and it may be hard to keep those core principles of arbitration alive while trying to expand the prevalence of arbitration in those fields. Just your thoughts on that, and I suspect we can keep that as the final comment and give you the opportunity to share your thoughts on that, John.
Okay, I mean, I agree with the premise of the question. The principles that apply to an international arbitration between parties from different countries with relatively equal bargaining power are not the same principles that should apply to an arbitration between, a consumer who signed an agreement to get a cell phone. There are very different principles that it should apply to them, and I think part of the difficulty we have in the United States is we have one Federal Arbitration Act that governs all of these things together and doesn't distinguish between them. And, unfortunately, I don't foresee any likely change to that. And I don't want to get into the way, the complex interplay between federal law and state law in the United States. It's complicated, but some states do have international arbitration acts. There's a California International Arbitration Act that applies to international cases. But, in the US, the federal law can sometimes preempt state law and override it. And so it's not the solution. What we need is a solution, I think, at the federal level, which I personally don't see forthcoming anytime soon. So I understand precisely where the question is coming from. And I think part of the difficulty in the US, arbitration has become politicized. And because of that, the two sides oppose each other. In terms of tailor-made, I mean, of course that is true, but I would not want to see that tailoring come from a legislative body. I mean, that's for arbitrators to decide in any particular case. What is the right set of procedures for this dispute? I think it's a recipe for disaster if we try to fix that legislatively. If the legislator were to say, oh yes, in an intellectual property dispute, this is how it should be done. In a consumer dispute, this is how it should be done. In an international case, this is how it should be done, at least at the granular level. You can have broad principles. And as I say, I think, the principles that apply to an international arbitration between two relatively equal parties aren't the same as apply to a consumer contract, for example.
Thank you, John, and I hope we've addressed the query that was raised. I mean, I had to end this over here, and thank you once again, John, for those very thought-provoking remarks. It was fascinating on the SIAC Academy platform to have this, have you share your views and thoughts on something which is almost right there, but yet never gets noticed. So it was fascinating for us to look at it. It gave us all the opportunity to rethink the fundamentals of arbitration, how they exist. And I hope and suspect that many of the participants who joined in will walk away from this feeling that they've learned something new and would probably ask themselves the question about the primacy of arbitration and the dominant theory and how that sort of interplays in the whole larger gamut of commercial cross-border dispute resolution. So thank you so much, John, for those comments. And thank you, Aditya, and thank you, Melissa, for very ably sharing all of your comments. It's back to the SIAC Academy, and thank you so much.
Thank you.
Thank you to our moderator and panelists. That was a really insightful and engaging discussion. And I'd like to say thank you especially to Mr. Fellis for his lecture. We hope today's lecture has provided much food for thought for everyone. If you can, please spare some time to complete the feedback form. The link to the feedback form has been sent to you through the chat function, and we hope to see you at our future SIAC Academy courses. Have a lovely evening, everyone. Thank you.
Thank you.
Thank you very much. Thank you.